Your Honour, I appear on behalf of Mr. Harris. This case was previously adjourned for a pre-sentence report to be completed. May I ask if Your Honour has received this and had an opportunity to read it? I'm grateful. Mr. Harris understands the severity of this offence and that the court today will be considering a custodial sentence. Nonetheless, I seek to persuade the court to impose a high-level community order in line with the conclusions of the pre-sentence report. With reference to page 800 in Supplement 1 of Blackstone's, I submit that this is a Category 3C offence on the basis that the incident involved low culpability and low harm. The starting point for this offence is 1 year in custody. The guidelines stipulate a range from a high-level community order to 3 years in custody, and I urge the court to impose a sentence at the lower end of that range. Before proceeding any further, I submit to the court that Mr. Harris should be given credit for pleading guilty. Although he did not enter a guilty plea at his first opportunity to do so, which would have been the plea and trial preparation hearing on the 7th of November, it was on the 27th of November when the court and prosecution were notified of Mr. Harris's intention to change his plea. On the 5th of December, Mr. Harris formally entered his guilty plea. I therefore submit that a deduction of about 1/4 would be appropriate for any sentence imposed today. Moving now to the circumstances of the offence itself and the factors that can be raised in Mr. Harris's mitigation. I urge the court to bear in mind that this offence did not involve any planning, and it was just an event of opportunism. Furthermore, Mr. Harris played a very minor role in the offence and was very much following the lead of 2 other individuals. Mr. Harris was not the one who took the wallet, nor was he the one that made those initial threats which led to the wallet being handed over. Mr. Harris also did not take any of the money out of the wallet and has therefore not financially benefited from this crime. These are significant factors in Mr. Harris's favour, which are raised in mitigation with relation to the circumstances of the offence itself. Moving now to Mr. Harris's personal circumstances. Of course, the court will be aware that Mr. Harris does have a list of previous convictions and will be concerned to see this. Nonetheless, I submit that the first 4 offences are of completely unrelated offences to the one before the court today, and therefore the court should consider them of no relevance in deciding what sentence to impose today. I do accept that the 2 more recent offences are of robbery and are therefore of a similar category to today's offence. Nonetheless, I submit that the facts of the previous offences can be distinguished from the facts of the case today. Those 2 previous offences were dwelling house burglaries. However, the offence today was a robbery that took place from an individual on the street. There therefore is clearly a distinction between the facts of the offences, and I therefore submit that this is significant enough to show that this is not a pattern of behaviour. Your Honour, it is also vital to bear in mind Mr. Harris's very difficult and chaotic lifestyle that he has endured. I submit that this provides some background information and understanding as to what he was going through at the time of this offence and explains his motivations for committing such an offence. Mr. Harris has previously been bullied, and he has also been in the care of the local authority since about the age of 12. This was because his parents were unable to look after him, as they themselves suffered from various substance misuse problems. Due to these difficult circumstances, Mr. Harris has previously been unable to complete his studies, and this has led to difficulties in him finding employment. At the time that this offence was committed, Mr. Harris was of no fixed abode. He was not in employment and he was of very limited financial means. He was at the time begging on the street, which highlights to the court the real difficulty that Mr. Harris found himself in at that particular time. Mr. Harris was at a particularly low point in his life, and I ask that Your Honour bear this in mind in understanding the background to this offence. Your Honour, it is also important for Your Honour to understand that Mr. Harris is extremely remorseful regarding this particular offence. Your Honour will see in paragraph 2.2 of the pre-sentence report that it states, Mr. Harris accepts his part in the robbery and regrets not admitting his role any sooner. He told me that he felt sorry for what had happened to Mr. Blake. This clearly shows that Mr. Harris feels very bad about his actions and regrets what he did. I ask the court to bear this in mind in Mr. Harris's strong mitigation, as clearly he is very, very remorseful about what occurred. Furthermore, I accept that Your Honour will be concerned to hear that Mr. Harris was under the influence of drink and drugs at the time of the offence. Mr. Harris unfortunately does have a history of substance misuse. However, he is currently in the process of trying to turn his life around. Mr. Harris previously associated himself with the wrong sort of people, who were also individuals who they themselves got themselves involved in drink and drugs. Mr. Harris no longer associates himself with those people and has tried to build positive relationships to have a better influence on his behaviour. Furthermore, if you look to paragraph 3.4 in the pre-sentence report, Your Honour will see that Mr. Harris has begun volunteering at the Ground Force project, which involves him cleaning and cutting vegetation in the community. In addition to this, he has received an offer from Hanham College to complete his GCSEs there in the next academic year. This clearly shows that Mr. Harris is taking positive steps to try and improve his lifestyle. If Mr. Harris were able to carry out his GCSEs, then he would have better prospects for employment in the future. Furthermore, it is key for the court to understand that Mr. Harris has now not drunk alcohol or taken drugs for the previous 4 months, which is his longest period of abstinence. This clearly shows that Mr. Harris is making significant improvements to his lifestyle and is really trying to turn his life around. Your Honour, as a result of the aforementioned factors, the probation officer concludes the risk of reconviction to be medium. However, if you look to paragraph 4.1 of that pre-sentence report, he explains that there is no immediate risk, but that if circumstances change, then he has the potential to cause harm. Your Honour, Mr. Harris's life is clearly on an upward trajectory, and provided that he be allowed to continue improving his life, then I submit that it is unlikely that he will commit any further offences. I understand that the court will be considering custody today. However, I urge the court to not impose a custodial sentence for the detrimental impact that it would have on Mr. Harris's life. Mr. Harris is currently in a period of stability. He is living with his mother, and his mother's partner is assisting him with the voluntary work and trying to help him find employment. If Mr. Harris were incarcerated, then this would destroy the level of stability that he has and would prevent him from reintegrating into the community. If he were not able to reintegrate into the community, then this would provide a greater chance of reoffending, and I therefore urge the court to not impose a custodial sentence on this basis. In conclusion, and in light of my submissions, due to Mr. Harris's strong personal mitigation, I urge the court to adopt the conclusions of the probation officer that the correct sentence to impose would be a 2-year community order with a rehabilitation activity requirement for 24 months and an unpaid work requirement of 200 hours. I also ask the court to make the necessary deduction for Mr. Harris's guilty plea. If I can be of no further assistance, Your Honour, then those are my submissions.